morning and welcome to the First District Court of Appeals. We have 3 cases that will be argued today. When I call the case, please, the attorneys, if you could state your name and your readiness to proceed. The first case is State versus Bradford.
Good morning, Your Honor. Krista Heesky on behalf of Pierre Bradford, ready to proceed.
Good morning, Ashley Tucker on behalf of the City of Cincinnati, prepared to proceed.
Thank you. The second case is State v. Johnson.
Sean Allenman on behalf of the state appellant, ready to proceed.
Laura Peters on behalf of appellee Siobhan Johnson, ready to proceed.
Okay, thank you. And then the last case is In re J.F.
Good morning, Your Honor. Margaret Kane on behalf of the appellant, JF, ready to proceed.
Okay, thank you.
Paula Adams on behalf of the State of Ohio, ready to proceed.
Okay, thank you. And I will be keeping your time. When you see the yellow light, you have about a minute to go. When you see the red light, your time is up. Ms. Giesky, if you'd like to come forward, would you like to reserve any time?
Yes, Your Honor. I'd like to reserve 2 minutes, please.
Okay.
Thank you, and may it please the court, Ms. Tucker. So I would like to proceed with the second assignment of error unless this court directs otherwise. And that assignment of error challenges that Mr. Bradford's conviction for violating a protection order is not supported by sufficiency or weight of the evidence. And the first issue raised was whether the streetcar platform constitutes a prohibited place as contemplated by the express terms of the CPO. So the protection order in pertinent part contains explicit terms about where Mr. Bradford cannot be. In particular, paragraphs 1 and 7 represent Ms. Spell's residence, school, business, and place of employment, including building, grounds, and parking lots. And paragraph 4 is the traditional restriction that he cannot be within 500 feet of any place that he knows or that Ms. Spell is or is likely to be. So Ms. Spell, as you know, is a streetcar operator. Mr. Bradford was ostensibly viewed standing on the platform at 12th and Vine. So the crux of this issue is the platform considered Ms. Spell's place of employment as contemplated by the express terms of the CPO? So what we have here is testimony from Donna Falks, who is Ms. Spell's direct supervisor. And she testified that the platforms were considered property of the streetcar. So specifically, she said that the platform at 12th and Vine was owned by the City of Cincinnati, leased by SORTA, and operated by the streetcar. So Mr. Bradford submits that SORTA's leasing of the platforms did not render them Ms. Spell's place of employment alone.
Let me ask you this, and what if the streetcar employees are housed in a building that's not owned by the streetcar or the City of Cincinnati? If it's just leased, then would you say that just because it's a leased property that he's allowed to go there?
I don't think
It sounds like that's what you were saying about this platform.
Somewhat, but it's not that black and white. So I acknowledge that there will be businesses that lease their facilities and don't own it. It probably happens a lot, right? And that just by virtue of a leasehold, we did argue, typically allows someone to use and occupy property but does not confer ownership interest. And I would say that that is not the only inquiry in this case. I think that the fact that SORTA and Metro and the city from whom they lease are all public entities adds a layer of analysis that really informs the outcome of this case. And that is because under the 14th Amendment, you have a right to interstate travel and intrastate travel. That is part and parcel of, there's city sidewalks. That's how this becomes different than a building as well. We have, the platform.
Let me ask it this way. What if he was
Sure.
standing on the sidewalk right outside the building where she's housed or worked? Would you say that's not a violation? And don't even consider the 500 feet?
Right. It does become difficult because the sidewalk is part of public property, right, that people
Right.
have a right to traverse. I think without question, the hub on Race Street where they get their paychecks and they can maybe clock in and out, without a doubt is contemplated. Even the express terms would say the parking lot is part of that. But the sidewalk is a bit different because that is how people, especially homeless people like Mr. Bradford, get around. So that adds a whole more difficult layer of to analyze this case. I wouldn't say a leasehold by itself means that just because they don't own it, they lease it, means that that's not contemplated as a violation necessarily. It's the fact that this is public property that really, you have to balance the leasehold interest with infringing upon the right to travel. And SORTA's, at least the Metro's 18 stops go all the way from the banks to OTR. That's a huge area. So under that revised code 30635, regional transit authorities like SORTA, their jurisdiction, so to speak, either is citywide or countywide. So where do we draw the line here? Where do we contemplate that? I would concede that if he got on the streetcar, violation. That is an easy violation. But this platform, which is adjacent to or even kind of on the sidewalk, we would say is not contemplated by the express terms of the CPO. And in this way, the Second District's Ball case,
So are you also saying that the platform is not a necessary part of the operation of the streetcar?
I would say it is, and that necessary part, yes, but that is contemplated by the 30635, that they can lease to accomplish, their purposes. It's a necessary part. But you have to keep going back to the CPO, which is like a contract sort of, right? What are the express terms? And to redirect it again to the Ball case, the Second District in Ball, the facts are totally not on point, but the reasoning is. And Mr. Ball was seen driving around the protected parties neighborhood, and the court, he was convicted of violating the protection order, but she was not home. And the Second District really hung its hat on the express terms of the CPO didn't say that he can't be traversing her neighborhood where she might be. It didn't expressly, it really kept bringing back to that contractual
In the
nature.
Ball case, wasn't it outcome determinative that the express language in the protection order required for the victim to be present in order for there to be a violation, which we don't have that language particularly in section 1 of the CPO?
What the Second District noted is that there was no reference staying away from whether or not she was actually present. That term is not in there. And if I go back to that first section, it's paragraphs 1 and 7, residence, school, business, place of employment. It does not hinge upon whether or not she's actually present, just like in the Ball case. That can be written in there, and maybe in future cases should be, but it's not in this case. And that is where the Ball case, the rationale is sort of not controlling because it doesn't bind this court, but instructive. I would like to briefly touch upon the first assignment of error if there are no other questions with the second. I think that this is an area where perhaps, the court could give some additional guidance. Ever since Hartman, 404B has been, other acts evidence has been, the Hartman court tried to hone it and refine that analysis, but the courts still aren't quite doing it right. Hartman is a 3-part analysis. This court has to be able to review it, so the trial courts should actually, do each part. And the weird part in this case is that the trial court said that this other acts evidence, which was, if you remember, it was in the form of the behavior that led to the issuance of the CPO. So Mr. Bradford going to Miss Falks, I think it was the hub, and throwing urine on her, which is a highly repugnant other act, right? It's a highly repugnant fact. So, of course, the defense wanted to object to that being brought to the jury's attention, and the defense offered to stipulate the CPO is issued and it's valid. So the court said that the Hartman other acts analysis was not appropriate, but then went on to do a partial other acts analysis and issued a limiting instruction that was an other acts limiting instruction. And what the Hartman court directed, what I wanted to really emphasize is that Hartman said other acts evidence, step 1 is relevancy. Relevancy, low bar, right? We know that. But Hartman said that the other acts must be relevant to a material element that is actually in dispute. The defense offered to stipulate to the protection order. They said it was completely valid, and you don't need to know why it was issued to see whether it was violated 1 year later by totally different conduct. So we would just submit that it would be beneficial to remind courts of the correct analysis under Hartman and to direct them to place their reasoning on the record so this court may more properly review it, which was not done in this case. So if there are no further questions, I'll reserve the remainder of my time.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the court, Ms. Geisky. My name is Ashton Tucker, and I represent the city of Cincinnati in this matter. I would turn first to the second assignment of error where Ms. Geisky started.
And can I ask you, was
Yes.
there a particular section of the protection order that, that he's charged with violating?
Let me.
Because the appellant cited 3 different sections, section 1, 4, and 7.
Yes. I want to say that he is. I do not have noted in my work, in my paper right now, what section that is exactly, Your Honors. But I would note that the relevant portion of the protection order itself, which is what Ms. Geisky said, is that the respondent shall not enter the residence, school, business, or place of employment of the protected persons named in this order, including the buildings, grounds, and parking lots at those
So it's your
locations.
understanding that it was one of the sections?
Yes,
It
yes.
That just happens to be number 1, but it's not
Correct.
a big deal.
Correct. Because we had testimony in this case that, from 2 people, that the people who work for the streetcar consider the streetcar itself, the grounds upon which the streetcar buildings are, the parking lots where those buildings are, the stops themselves, the platforms themselves, they consider those their workplace. That the court, or the trier of fact, rightfully considered that the workplace. It would be a different story if Mr. Bradford were walking the streets, let's say perhaps just passing by a streetcar location. But that's not what was happening in this case. In this case, this person, Mr. Bradford, was on the platform. The platforms are part and parcel to the streetcar itself. I would say that I don't think that that limits Mr. Bradford's travel throughout downtown. There are several other streets that he can go through. There are several stops for the streetcar, and the streetcar itself does make a loop through downtown, but there are several places that it doesn't stop. That's one of the main complaints about the streetcar itself, in fact. So it's not as if he is restricted in his movement, it's just that he is restricted from being on the platforms themselves. The platforms are part and parcel to the streetcar and its function.
Just for clarity.
Yes.
And I've ridden the streetcar, but I'm just trying to picture this. It is a separate, there's the sidewalk and you actually have to go up a little bit to get onto the platform. It's separate from the sidewalk.
Correct. So I would say that there's the sidewalk and maybe 10 feet to the right of a person is where the platform itself would be located. There is a ramp up onto the platform. It is not as if it is just a separate part of the sidewalk. The sidewalk is one thing. It would be completely different. I think the appellant would have a completely different argument if Mr. Bradford were just, happening to pass by a streetcar stop and somebody noticed him there. That's not what we have here.
Well, that's, what's interesting about the argument is that it's using some of the language from the other sections. So like section 4 has the 500 feet stay away. And so it's using that language in order to define the section that he violated.
So again, let's assume then that if that is the section, the platform is certainly.
Well, the section is one that doesn't have that language in it. There's a separate section.
Yes.
It has language of 500 feet, but it also has that the respondent would know or should know that the protected person is likely to be at.
Correct.
But that's left for another day.
Yes, Your Honor. For argument's sake, I would argue that the platform is less than 500 feet away from the streetcar itself. That being said, there's been some mention of whether or not, because this is a public property, that he has some right to it as a citizen. I agree that generally that would be true. However, that right to public property is not exclusive based off of his own actions.
And I think that, I understand where you're coming from, because it sounds like the argument is because it's public property, then it cannot be regulated through the protection order, which it sounds like that's the argument, but I think what the real argument is because it's public property, it cannot be considered part of the place of employment.
Certainly, and I would argue then that the place of employment or its nature as being out in public is separate because it is not like a sidewalk. It is actually a part and parcel to the streetcar's operation. Not only that, but it's separate from the sidewalk. You do have to make a concerted effort to get onto a streetcar platform.
Was that argued and developed in record below?
I'm sorry.
The separateness of the platform of the
Yes.
streetcar, was that argued and
Yes.
developed in the record below?
Yes, there was some testimony as it related to the distance between the streetcar platform and the sidewalk, whether or not the prosecuting witness in this case considered the sidewalk as part of her workplace or the platforms themselves. And it was very clear from her testimony that we were talking about the platforms, not necessarily the surrounding area.
What's your position on the relevance, if any, on the State v. Ball case?
I would argue that I don't think that it is relevant.
And why is that?
I think that what is relevant here is what the trier of fact had in the record at that time, which was that this was this person's this prosecuting witness's workplace, that she considered it her workplace, that it was considered the workplace by several members of her office. I think that is what this case, or this particular case, hinges upon. And just turning back towards the first assignment of error, I would argue that the three essential questions were answered by the trial court, that this was relevant to
How was it relevant?
Sure. It's relevant in the context of why this was issued.
Why does it matter? They conceded
Certainly.
that there was a protection order in place. Then there was the protection order, the redacted protection order that was given to the trier of fact.
Yes.
That said exactly what the defendant was prohibited from doing. So please explain to me how it's relevant, why it was issued in the first place.
It is my position that when you have a jury, it is important to give them the facts that you believe that they will ask about. I think that having a well-rounded story of the circumstances is important here, and that is why it was being offered.
But that's not what he was being accused of at that time.
Certainly not.
He was being accused of violating this order. So that's the only thing he was being accused of. So why does it matter what he did about a year earlier?
Sure. My position remains the same, is that the contextual nature of it and trying to make a well-rounded picture for the trier of court or trier of fact. Further, it explains the victim's frame of mind when she was informed of the.
Does it matter what her frame of mind was?
I think that it matters to a trier of fact when it's a jury.
But isn't that an improper consideration, though? I mean, isn't it improper for a jury to consider behavior from a year earlier when they're determining whether the current behavior was a violation of the CPO?
Certainly, and that's why a curative instruction was made. For example, this is from transcript page 165, states, "I do expect that the evidence you will be hearing is received about the commission of an act other than the offense for which the defendant is charged. This evidence is being admitted to provide context as to the issuance of the civil protection order. It is not received, and you may not consider that prior conduct for any purpose." Once the term assault was used, the court then stated assault is a legal term, and as a result, I'm sustaining the objection to that term. You are to regard the terminology assault, or reference to the word assault as you consider the testimony. And
Under
that jury
Hartman,
is-
though, under Hartman, well, let's go to relevancy first,
Yes.
under Hartman.
Sure.
So under Hartman, when you use other acts evidence, which this certainly was other acts evidence, you have to show the relevancy to the particular purpose for which it is entered. Correct?
Correct.
Okay, so can you explain, first of all, what purpose? Other than context, let's leave that out.
Sure.
So if I think originally the state argued that it was being entered for something else. I can't remember the exact reason in the transcript. But for what under Hartman, what purpose, and how was this relevant to that purpose?
Certainly. So under Hartman, the admissible reasons establish motive or opportunity, intent, preparation, plan, knowledge, identity scheme, system, or absence of mistake or accident. For one, I would state first that the list is not exhaustive and shouldn't be confined to that. But if it were, I would say that this does certainly go towards the defendant's knowledge where he should be, where he should not be, as their only interactions were on streetcar property, as well as an absence of mistake.
Thank you.
Again, it's not being offered to show propensity or action in conformity with. Rather, it shows lack of mistake, as I indicated, considering that he was aware of the protection order and where he could be or could not be, given that his only interactions with the prosecuting witness were on streetcar property. And for the reasons above, that this is more probative than prejudicial, but even if the court did find that there was some prejudice to Mr. Bradford as a result, the court did issue 2 curative instructions, one prior to the testimony, one after the testimony, and this court should presume that the jury does follow those instructions. And unless there are any further
I
questions.
just have one further
Yes,
question.
please.
Let's say we were to disagree with you with regard to the 404B violation. What would be your position on whether it was prejudicial?
My position is that it would not be prejudicial. Again, given the fact that there is a curative instruction, there are 2 of them, in fact, we have to assume that the jury followed those instructions. Additionally, I believe it was also in the jury instructions themselves what they can consider. I think that there's nothing in the record that would show or lean towards showing that the jury in any way lost its way there or considered any additional facts other than the protection order and the facts that sustain the violation.
Well, the way that we have to look at it, though, we have to determine whether the error was not harmless beyond a reasonable doubt. There has to be no reasonable probability that the testimony contributed to the accused conviction. So it's not just whether the jury lost its way. It's a much higher standard than that.
I don't think that the record would show that either. I think that the record is very clear, given that the limit of the testimony by Ms. Falls, speaking about the incident that occurred a year prior to this. And I think that the curative instruction was sufficient. If there are any other questions, I will submit on my brief. Thank you.
Ms. Casey, you have about 6 minutes left.
Okay, thank you, Your Honor. Briefly, regarding the second assignment, the sufficiency and weight, I'd like to clarify that what the lay people who work for Cincinnati Metro subjectively understand to be the place of employment is not determinative, that this court would be tasked with reviewing the question of law and interpreting the contractual-based provisions of the CPO, and whether whether the facts meet those prohibitions. So really what the people think is the place of employment is not the controlling inquiry. Regarding the first assignment of error with the other acts evidence, and one other thing with the second assignment I'd like to briefly mention is that yesterday in the United States Supreme Court, there was a case argued called City of Grants Pass versus Johnson. And just to note that homeless rights and the impact of homelessness, and that had to do with, can cities enforce ordinances against public camping when the homeless people have nowhere else to go? So this, and it's actually a cruel and unusual punishment analysis. So it's really interesting. This issue is at the forefront of, the federal highest court. So
Well, let me
we
ask
may
you this.
see it.
Wasn't the real issue in this whether he was allowed on the streetcar or not? I mean, there's an order saying he's not permitted. It's a little different than saying you can't camp in Grant Park or Washington Park.
But he
Right.
wasn't, he
I mean,
wasn't
he was
on the,
prohibited from being on the streetcar
Right.
for that court order.
right, and he
So-
wasn't on the streetcar.
Well, okay.
Yeah.
I know, yeah.
That's actually the crux. He was on
Yeah.
this area
I
right
know.
next to it. That's actually the difficult part of this
That-
case.
Doesn't that, okay, we've argued that about the right of people to travel.
Mm-hmm.
Wouldn't the fact that there's an order saying you're not allowed on a public streetcar, wouldn't that touch upon one's right to travel interstate or intrastate? Do you understand what I'm saying? He's prohibited from doing it, and would your argument be this order's unconstitutional then?
That might have been an interesting argument to make. It wasn't preserved, but exactly that way. But
Well, I don't think it is, but,
it's, I think it's interesting.
yeah, you're right.
So with the first assignment of error, because, Hartman, I think, is a really important case. And I think, Judge Bach, you had really hit the heart of the matter, is that the prejudice prong. So number one, the initial offered reasons were, I think, intent, lack of mistake, and there was one more, knowledge. Those were the initial non-propensity purposes that the state then abandoned at trial and went with context. And the trial court, one reason counseling in favor of reversal is that the trial court said this is not a 404B analysis, then did a partial 404B analysis that, in a lot of cases, that's not going to make a big difference, but in this one it does, for a number of reasons. And the heart of it is, if this, it's a urine throwing incident. There are not many things more repugnant than getting a bodily waste fluid splashed on somebody. That's gross. So the average juror is going to be, it's hard to unring that bell. They're going to be pretty disgusted.
Well, let me ask this then. Someone that throws urine on another person, I assume they're laboring under some mental illness, or they could be a jerk or what have you, but you're asking us to presume some sort of prejudice by that evidence coming in. I guess if we're going to speculate, we could speculate that the jurors got to watch him during the entire trial. They got to hear the testimony about him. Maybe they felt sorry for him. And we can speculate the other way, that it had no effect whatsoever, even assuming it's error. If it was error to admit it, not every error is reversible error. So,
Correct.
do you understand what I'm saying? So you're asking us to
I do.
speculate one way, but not the other.
This is the big problem with the third Hartman prong, is that it often, 90% of the time is going to involve some amount of speculation.
Well, I don't even think it's 404B. I think it was error. Okay, I'll agree with you on that, but I don't think it had anything to do with this particular case, but the question is whether it's reversible error. I don't think it's 404B evidence at all.
So if you want to go just the error route, the correct analysis is going to be, was it harmless beyond a reasonable doubt? When you say it's error, then it's the number one, the burden's on the state for that. And I don't think the state's brief even robustly tried to counteract that. And number two, if you just you can still just look at the general repugnancy and say, if the jury, imagine they hadn't heard that at all, hadn't heard that incident at all, and this was solely based on him standing on a platform, would the jury possibly have gone the other way? Absolutely. That's more of a
Let me
bland.
ask you about that. The evidence of him being on that platform, are you saying that was not clear?
I think trial counsel tried to sort of, if you're talking about an identity type argument, I think counsel if I recall from reading the transcript, sort of tried to say like, oh, he allegedly was seen on there, and all we have is Ms. Falk saying he was up there. I didn't pursue that on appeal, only because I think that, I think there was some talk about clothing. And it was kind of like, okay, that's a concession that I think we have to make as he was up there. But
Because
trial
it seems
counsel,
like that's not being contested, that he was up there.
Yeah.
So the issue is whether the platform
Right.
is a place of employment,
Right.
right? And that's more of an issue, a legal issue than a factual issue.
it is.
So how is it that the jury would, how would the trier of fact be prejudiced by the throwing of the urine in a legal issue when a factual issue is not at hand?
Because lay people can't do what this court can do. You know, lay people are swayed by things like that, their personal repugnance. The question of law goes to really the first assignment of error and the other acts analysis. The sufficiency and weight analysis is what more closely contemplates that does this constitute part of the place of employment. But I would argue that the average juror is swayed by such things. So even though I can present it as this is a purely question of contractual law type of thing to this court, the average juror doesn't work that way.
So we shouldn't presume the regularity?
Presume irregularity or regularity?
Regularity?
We don't need to. We have a
Jury did their
transcript.
job.
You know, I don't think that presumption applies here. And if anything, if I go back to the first assignment, the other acts assignment, is that we have a trial court saying this is not other acts and then applying an other acts analysis. That is highly irregular. Either they're doing respectfully, the incorrect thing, the incorrect analysis, and saying they're doing it. So, and then you have the prejudice prong is what it turns on. And unfortunately, prejudice is often a speculative analysis. But we cannot eradicate the third prong of Hartman. We have to, give it some teeth. So I think that it is not a far jump to say that a group of lay people hearing that someone had urine thrown on them might have changed the entire outcome. So,
Your time's up, Ms. Keesler.
okay, if there are no further questions, I would ask that this court reverse and remand for a new trial or discharge Mr. Bradford. Thank you.
Thank you. Your case has been submitted, and we will issue a timely decision. The next case up is State v. Johnson. Mr. Donovan, how much time would you like to reserve?
About 4 minutes, please, Your Honor. It's not a question I'm used to answering, so I had to think about that for a moment.
Does the chair feel differently?
A little bit. Your Honor, may it please the court, this case involves a constitutional challenge to a statutory speedy trial violation. I know that there's some discussion about a statutory violation in the briefing that it had been raised below. However, the entire basis of the hearing, the entire context of the hearing, and the court's decision-making process makes clear that it was being analyzed under the Barker v. Wingo four-factor test and under a constitutional challenge, not a statutory challenge. There's no discussion about tolling events or anything like that in reference to the open container. It's all exclusively as to the officer's, Officer Musgrove's attempts at service in this matter. And so I believe that it's appropriate to address the Barker v. Wingo. And as this court has held, failure to address any of the four factors in that constitutes error on the part of the trial court and requires reversal. In this case, it's very clear that the court never made any ruling as to the fourth and the most crucial, according to the Ohio Supreme Court and this court, the prejudice factor. The court, we agree, the 15-month, that's the threshold issue that gets you in the door, that then requires evaluation under the other three factors. We agree there was a timely assertion of right. Although the trial court doesn't make a finding on that, we don't believe that that's necessary. That would have been our responsibility at the time to raise that challenge if we felt that it wasn't there. So we agree on those two. The court, in making its decision, said that 15 months was unreasonable. The primary officer exercised, despite his efforts, I believe is the language that was used, and those efforts are he went to her address at least 3 times. He said he called her phone number. He went to a separate address, and then when he discovered a prior OVI was still pending, he asked those officers to try and serve Ms. Johnson at that hearing, and she capious. She didn't show up to that hearing. That's what we have in the record. There's some controversy on that, but what isn't, I believe, controversial is that there's absolutely no affirmative showing of any kind of prejudice, and there's no showing that the court effectuated its responsibility to address the prejudice problem.
There were some cases that prejudice could be presumed. Would you agree with that?
Yes, ma'am, and so, but
So the question is whether this is one of those cases.
well, and there's certainly like in Wilson or in Duncan, or I believe, I'm going to mispronounce the name, Mohamedel, I believe is the proper pronunciation. I could be wrong. But in those cases, there's that prima facie showing, but then the amount of weight to be given that prejudice is determined by pretrial incarceration, which was not the fact in this case, nor was there anxiety based on awareness of it. So as this court found in Wilson, that length of delay was afforded minimal weight in terms of that in the absence of an affirmative showing of actual prejudice. And in this case, the entire argument is one that could be applied to any case. There's a generalized statement that evidence could have been lost, memory could have been deteriorated. It's a boilerplate assertion that prejudice ensued in this, in both the motion and then more significantly in that the trial court didn't make any sort of finding as to prejudice.
I think it could be said that there's always going to be prejudice. The question is whether the prejudice really rises to a certain level. There's always going to be prejudice. It's impossible to say there's never prejudice.
There absolutely
It could be
can.
de minimis.
Absolutely, and that's what the 4 factors and the balancing test says, and that I believe the language is egregious and aggravated cases where the delay was deliberate or intentional, whether there is any sort of bad act. But absent that, and absent the pretrial incarceration, and absent the anxiety there has to be some sort of affirmative showing. I believe this case law is clear on that, and in this, there's no what witness isn't available, what witness's testimony, what lab result, what report. And in the brief, there's a discussion about the potential speculative lack of access to body-worn camera videos, but we don't know whether, there's absolutely no discussion about whether Springfield Township has BWCs, whether or not they were retained, whether they were retained in this case or not. So speculation about notoriously short retention periods in this doesn't make that burden, nor was that argument addressed to the trial court, nor did the trial court, coming back to my initial point, make any sort of finding on the prejudice prong. And that, as it was in Wilson, is fatal to the trial court's determination and demonstrates error on the part of the trial court.
It seems like a significant prong of Barker is sort of the animus of the state. In other words, whether it was intentional, and there's case law that has developed with regard to that. And then negligence, there seems to be case law developing as to whether there could be such a high level of negligence that it starts to become treated as if it's intentional. How would you put this case in that sort of spectrum?
I would compare it to like in Wilson, in which this court said the officers less than stellar, I believe, was the description of the detectives' efforts in that. And that, I believe, if I remember correctly, it was 2 phone calls and a text message almost immediately after the event, and then the warrant was filed and included no address in the warrant that was filed because they were informed that the last known address wasn't correct, and it was filed and nothing else happened for 9 months. And this court found that because there was no affirmative showing of prejudice, there was no pretrial incarceration, there was no anxiety, once again, going back to that point, that wasn't sufficient. That even considering those less than stellar events, I believe in Duncan, I think that the attempt was through certified mail. Comparing to that, and I acknowledge that in Wilson, I believe it was a 9-month delay, which is a shorter delay in this, but we have significantly more diligence being asserted by the detective, Officer Musgrove, in this case. Multiple visits to the house, multiple avenues of trying to make this contact. And finally, I come back to the trial court in its decision says that the other OVI was a subsequent OVI. It wasn't, it was prior. That's clear on the record that it was prior and it had been pending. The court said that that was taken up to sentencing. No, that the term sentencing is never discussed in the trial court. There's no testimony as to that. There's no evidence to support that statement. There's a statement, a compound question that is asked of the officer, was this case completed? And then there was another question that was also in that. And the officer's response, even if it is his saying, yeah, and then the following response deals with the second question in that question, even if that is an acceptance of that the case was completed, there's no indication that that meant sentencing. Perhaps the case was acquitted. Perhaps it was dismissed. Perhaps, a jury trial. We don't know what happened in that. So clearly, the trial court erred in saying that, basing its decision on that, that case went to sentencing. There's also no indication that at any subsequent hearing, the last thing we know is that Ms. Johnson capiased in that case. There's no indication that at any subsequent hearing she was present. Perhaps it continued to capias, but it got dismissed for some other reason.
So you're saying the
no
trial court made findings of fact that are not supported by the record and then weighed those facts too heavily. It sounds like that's what you're saying.
Yes, ma'am. Weighed the actions of the brother officers and lumped all of Springfield Township together against that officer. And while that would be an interesting argument, it wasn't one that was raised. And even if I concede that the actions of the other officers in pursuant to that they should have been trying to serve the warrant. In addition to Officer Musgrove, they should have made additional attempts. There is no indication that Ms. Johnson was available at any of the other hearings. And so there was a presumption on the part of the trial court that I don't believe is supported by the record, and I believe actually is contradicted by the record in some cases where he says subsequent as opposed to prior. And so I think that weighed too heavily. But it all comes back to there was no evaluation of the prejudice prong, and therefore it demonstrates error. You see, I'm
So-
about out of time.
You have about 30 seconds until your
Yes, ma'am.
initial time's up. So is your remedy for us to reverse for findings on prejudice, or to reverse because there were no findings on prejudice?
I believe that the reversal, and I would have to confirm on Wilson, however, it's just a reversal of the trial court's decision.
Let me assist, Mr. Donovan. You talked about the prejudice prong. And how would you propose a defendant demonstrate that prejudice, other than maybe asking the police officer whether they hit a body cam, and that didn't happen in this case, but asking, was there a body cam? Do you wear body cams? Did you preserve it, et cetera? I think there was some mention in one of the briefs that maybe her witnesses weren't available. something like that. There's no evidence of that. How would a defendant demonstrate prejudice, at least in your mind, other than what I've already said about cross-examination?
I think that it would make it a closer case that the claim of prejudice in this matter could be cut and paste into absolutely any fact pattern. And so by that very nature, that's insufficient. I think that if there were potentially a discussion about other witnesses, about, if there's some sort of specificity in terms of what was lost, how they were prejudiced by this, there needs to be something more. And the court has said that there needs to be an affirmative demonstration of that. I think that asking, had there been body-worn camera videos? Now in Wilson, I'm sure counsel will point out that in Wilson, the state affirmatively asked the officer if the interviews had been recorded, and the officer said that yes, they had been. So there was a preservation, there was a demonstration on part of the state, but I believe it's their burden under Wingo to show, or under Barker, to show that there was some prejudice, and the speculation, a generalized speculation, is insufficient, sir.
Thank you.
Thank you.
And just
Yes, ma'am.
a question, okay? And I understand what you just finished saying about the burden with regard to the prejudice prong. With all factors on Barker, who has the burden?
I think that in terms of once that initial threshold, in terms of the first
timing.
factor, that initial factor is that in terms of establishing reasonable diligence to negate that, I believe that would be on the state. And then in terms of the assertion of right, that's clearly, I believe that would be on the defendant. They need to assert their right in that case. And then in terms of the final factor, the prejudice prong, I believe that the burden is on the defendant to make some affirmative, particularized showing, and I believe that the case law supports that.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the court, I'm Laura Peters. I'm here for appellee Siobhan Johnson. In this case, Siobhan raised two different speedy trial rights. First was the constitutional, and then in the supplement motion raised her statutory speedy trial rights. And I respectfully disagree with Mr. Donovan's representations that the statutory speedy right was not important, or was never further developed. Because when in the case, in the testimony, defense counsel, and it was clearly elicited as to when the speedy trial clock was going to run, when it was going to start. And that's because she elicited, and through testimony, that the officer knew at the time of the offense that he could have charged her with the A1A OVI, the assured clear distance, and the two other driving under suspension charges. He could have charged her that night, and she was charged, and he also referenced on that ticket the open container, which she was charged with that night. So there was testimony elicited that when the speedy trial clock started. And then you fast forward into when she's finally served with a warrant on that, and that's not until February of 2023. That's well beyond the 90-day speedy trial time limit. So they presented a presumptive prima facie case of statutory speedy trial right violations.
Let me ask you a question about that, because my understanding is on the statutory speedy trial right that it's either arrest or service of the complaint. So you're saying that when was she arrested on it?
She was arrested, so she was served with the complaint on the open container charges. And because all the facts that arise from the OVI, the shared care distance and the suspension charges arise from the same set of facts, they use the same date as to when the speedy trial time starts.
But it says service or arrest, so.
She was served with the complaint on the open container.
Okay. All right.
And so you relate those charges, you relate the later charges back because they all are based on that same incident, and the officer knew at the time he could have charged her, but chose not to. So the prima facie case was established, therefore the burden shifts to the state to explain any tolling or waiver periods in which the state didn't do that. So, and that's not the fault of the defense. The state had that burden. So the statutory speedy trial ground plus was raised in the defense's written closing remarks. So this was well before the court, and the court issued a generic judgment entry just saying MTD is granted. We don't actually know in the judgment entry which one he's referring to, whether it's both or just the constitutional. But even if we have to go on the constitutional, this case, she satisfied all the burden. The main issue here.
So it sounds to me, so that you can move on to the other parts, it sounds to me that because if it was determined on the constitutional, then certainly there was no need at that moment for the trial court to make a determination on statutory, right?
Well,
And so
we know.
let me
okay.
just finish, okay? I think you'll like my ending.
Okay, good.
Okay. And so, because it was decided on the constitutional, even though both were presented, then even if we agreed with the state that the statutory can still be determined by the trial court.
Yes, but I would also say because the actual judgment entry, which the court, as you know, the trial court speaks through its journal, just says MTD is granted. So it could have been granted on both or one. And because of the alternative basis in the state's failure to raise as error the statutory speedy trial grounds being improperly done or improperly granted, their appeal is, to me, fatally defective because the journal entry itself is generic. They didn't ask for the trial court to clarify whether they're just doing the constitutional or the statutory. But even if you don't accept that and say, well, because of the hearing, he only focused in on the constitutional, we still assert that the trial court's decision was correct.
So then based on that, now I understand what you're saying. So what you're saying is because of the language in the judgment entry, that it could have been granted as to both,
Yes,
which means that, in a way, we're kind of done, right? All right, so.
yes.
But I also hear you saying that it is a bit nebulous as to what it is that actually occurred. Wouldn't it be proper for us to then remand for clarity from the trial court as to what was granted?
No, I think you have to presume the regularity of the proceedings, that the trial court granted it on both, and that the state's failure to challenge both on appeal means that you affirm the trial court's decision. But even if you don't choose to do that, I would still say on the constitutional, that if you choose not to do that, then yes, I agree with you that it should be remanded for consideration of the statutory
And what would you
speedy
say that
trial.
the transcript reflects as to what was decided?
I didn't quite hear.
What would you say that the transcript of the proceedings reflect as to what was decided,
And
as to what was granted?
Yes, on the August hearing, the volume 3, the third transcript, yes, I will acknowledge that the trial court only seemed to apparently address the constitutional speedy trial part of the motion to dismiss. But again, if we say that the court speaks through its journal and the journal is a generic, you presume the regularity and that the trial court considered both and granted both. Turning to the constitutional, my argument is basically, yes, you can presume prejudice in this case. I know the state relies heavily on Wilson, but Mr. Donovan didn't acknowledge, in Wilson, there was at least some affirmative evidence in that case that the evidence had been preserved. In Jackson and Pierce, I think it's Pierce, Pierce was a 15-month delay and that you presumed prejudice because of the lack of effort. In Jackson, after 1 month, there was no effort. Well, that's what we have here, essentially. The Officer Musgrove testified that he didn't do any attempts to serve her after possibly December of 2021.
But there was an attempt, though, wasn't there? I mean, it wasn't
He
him
didn't.
personally, but it was the Springfield Township Police Department attempted to serve her in court on a different matter, and she was a failure to appear, correct?
Potentially, yes, once. The transcript is a little unclear as to when that effort occurred, whether when Officer Williams, who was on the February OVI, went to court and returned the warrant to Officer Musgrove. From my own investigation, I think that occurred in April of 2022. But then let's go back to what he's testified, what happened after that. After April of 2022, that warrant went back into the drawer, that's what he testified to, went back into the drawer. There's no testimony of any other effort to serve her. So as Doggett tells us, when there's no effort like that, it compounds over time. So you have almost 10 months then of no effort, of zero effort. So you should be, so that's not reasonable diligence, and that when you presume prejudice, it's the length of the delay and the effort, and there's absolutely zero effort, as like in Jackson and in Pierce. The state also mentioned Duncan, but in Duncan, the police officer had to ask the casino, they had made some effort to say, hey, if this guy comes back, can you notify us? So there was a little bit more of periodic notice. So that's why prejudice wasn't presumed in Duncan. And Muhammadal, the defendant was homeless. So they said, without a stable address, it was hard to presume prejudice or to say that they lacked reasonable effort to serve him because he didn't have a stable address. What do we know in this case? She had a stable address. The address that she had in November of 2021, when she committed the offenses, was the same address that she had in February of 2023. Because the officer confirmed that, like when he wrote the ticket, he confirmed her address. Yes, it was the same address. We don't know. He never explains, did he just drive by the address? Did he actually knock on the door? Did he talk to anybody? Was it an apartment building? Did he talk to neighbors where she might have been? We don't have any of those details. We have details in the other case where, like, certified mail was sent to the address and returned, undelivered. And that was the Duncan case. We don't have that here where, did he mail anything to her at that address? There's no evidence because he doesn't testify to that. He says he went to the address maybe 3 times, went to a Clover Nook address once, and called maybe multiple times. But he doesn't say whether he left any messages. He doesn't say whether the phone was disconnected, was the voicemail full. The state didn't elicit this testimony to explain their reasonable efforts. And so what we have here, and then if we say April is the date that they try to serve her in court, well, and contrary to what the prosecutor, Mr. Donovan said, I disagree. He says the February OVI was resolved, was the question. Was the February OVI resolved prior to, and he said, yes, I was shocked she wasn't served because in my experience, a bailiff would have notified us to come serve her. So so we know that she appeared in court before she was actually served when the Woodlawn police pulled her over. So we know she was in court because he says, yes, it was resolved, and I was surprised we weren't notified. And we know and not only
Ask you something just for my own clarity. The case that the officer was relying for service to occur during the court proceeding, is that a different case or the same case that you're referring to that there was testimony that it was resolved?
If I understand your question, it's the February OVI is, so what I'm saying is that case was resolved, yes. So on page 32 of the transcript, the question was questioned, and that case worked its way through the court, and we're referring to the February OVI. I know you weren't involved in it, but it sounds like you kind of knew the other officers who were. That case had worked its way through the court and was resolved. Yeah, I didn't know about it until we got to this case, because I was very shocked she was not served. And then he goes to explain how he used to be a bailiff, and that bailiffs, when they saw an open warrant, would let them know so that they could come and serve warrants.
And that's a different case than the case that the officer was relying that she would be served when she appeared and then she didn't appear in court.
It's the same case, but
It's
a
the same
different,
case.
yeah, but a different time.
But a different hearing or a different.
Yeah, a different
order.
hearing, yes.
Okay,
So
that's what I was
yes.
trying to figure out. So that was the
Yes,
same
it's
case.
it's the February OVI. He went, but, yes, and this court can look at the docket.
Which is.
And we know that from the
Which is
doc-
presumably why there was some element of surprise, because they were already have been asked to notify or to serve.
Right, and that there was a failure to appear.
Okay.
And then, yes, but since then, he had learned that that case had been resolved, and that case was resolved prior to her being served.
Then I have another question. At the onset of the argument on this point, you talked about how there was 10 months in which there was no effort at all. And you were asking us to look at that period of 10 months of absolutely no effort at all. Should we be looking at that period separate and apart from the period in which there was effort? Or do we look at the whole thing in total?
You can look at it, I think you look at it in total, but what you have is, so you have the incident occurs November 12th of 2021. And we have Officer Musgrove testifying about what his efforts are through the end of November and possibly into December of 2021. And then at some point in time, that concludes his efforts to serve her, except for asking Officer Williams to serve her at a court hearing. And he doesn't really explain when that happened, but I believe it happens in April of 2022. So between the December of 2021 and April of 2022, again, there's no effort. There's no testimony of any effort to be made. There's one effort. She doesn't appear for an on the February OVI, and then the warrant goes back into the drawer, and then nothing happens until Woodlawn calls on February 14th of 2023. So I think it compounds. You look at it in its totality, but I do think once you see that there's a big chunk of time where there was absolutely no effort to serve, and apparently wasn't going to be since it was placed in a drawer.
Should we be looking at whether those 10 months are reasonable in light of what the officer knew? Do you understand what I'm asking?
Yeah, I do. Just,
Which, there's an overlay to that question, to my initial question.
right, because we
It's
don't know why she didn't show up. So we don't, but we don't know why she didn't show up for court that day.
Well, I mean,
It's-
what we do know is the officer was told that the address that the officer understood to be her address was not a good address,
That is not accurate,
okay?
because
Is it something I misunderstood, or is it something that's not being represented accurately?
he said that wasn't her. He looked at a different address, the Clover Nook, because it was an address that had popped up in RCIC. So he did go there, and that was not a valid address. But we do know from his own testimony that the address she gave the night of the incident is the same address she gave to him on February of 2023, when she was finally served with it, that Toluca address was her current address, and it had been her address.
And that's not the address that the officer was alerted was not good.
I don't know that there, I don't recall there being any testimony about an address not being good.
Okay,
I know that was in case law. That's in the Wilson case.
okay.
But, so, seeing my time has expired, we ask that you affirm. Thank you.
Thank you. I gave Ms. Peters a couple of extra minutes. I'm going to give you your full 4 minutes since you had questions asked towards the end, so.
Thank you, ma'am. First and foremost, there's a lot of discussion about April. That's absolutely not in the record. And so it inhibits my ability to respond as to when her case on the other OVI was actually resolved and what actually happened in that, because there isn't any testimony as to that. There isn't any testimony as to that it was resolved in April of 2022. And any assertion that we can look to the record, I would be happy to. However, it wasn't in part of our record below, and it's not appropriate to evaluate anything in this based on evidence that's not in the record below, and that was never presented. So the April that keeps coming up, not part of the record. I'll go back, Judge Zayas, to one of your final questions that you were asking about the reasonableness of the 10 months in light of what the officer knew. That's absolutely what we look at. We look at the efforts that were made prior to that 10-month. And if we compare it to, I believe it was Wilson, where there was the 9-month delay on the less than stellar, they didn't do anything and waited 9 months. And because there was no evaluation of the prejudice prong, the trial court had erred. And so in this case, we have multiple trips out to this address. And if it's a good address, I would argue that that weighs against that, because the officer went to her actual address. The officer called her actual phone number. And yes, there is no testimony as to whether he left a note or whether, the time, place, and manner in which he did there. But he said that he went there at least 3 times. He called her at least once.
But I
He
think
went-
Attorney Peters' point, and I see the error of my ways of that fact. I think Attorney Peters' point is that we have a good address, and so even though the officer attempted, it sounds like 3 times, to serve at that address, that in light of the fact that we have a good address, that would be unreasonable.
I would say the officer tried at least 3 times is what he said, but the law doesn't require, the officer to go out once a week, every week to that same address. As far as he knew at that time, he's gone to that address 3 times and wasn't able to locate her there at least 3 times. So subsequently to that, she then says that that has been my address the entire time. But based on what the officer knew at the time, and whether, and this goes to his reasonable diligence in what he did, he's gone out to this address at least 3 times. There's another address on Clovernook that's in RCIC. At that point, it's reasonable to assume this isn't a good address. And then in terms of what happened and why she didn't show up at this.
Is that what the officer testifies, that he assumed that it wasn't a good address?
He did not, ma'am. I'm saying that is a reasonable inference. He did not testify. I assumed that it wasn't. However,
Now, it seems to me, based on your prior argument, that even if it was unreasonable, that the lack of the evidence, any evidence on prejudice, ultimately defeats it for the defense.
I believe that is what the case law says. Even if we find that the officer's efforts in this were less than stellar, which I don't believe that there's any sort of finding as to that the failure to address the prejudice prong negates, that invalidates the court's entry and requires reversal of the court's decision. And I think that the context of the entirety of the argument. And yes, I did not address the statutory argument that's now being raised. There was no testimony as to tolling and things like that, because the understanding and everybody proceeded on that. And the court's ruling is based on a constitutional challenge under Barker.
So how would you address the argument this morning that the trial court speaks through its entry, and that although the transcript clarifies the point for us, that the trial court speaks through entry and that's outcome determinative?
I would say that one, as a prosecutor, I know how many times I've been turned over because the court says, not well taken and denied. That's insufficient, particularly in light of the fact that the statute and the criminal rules require on the decision on a motion to dismiss based on speedy trial, 12F requires the court shall state findings of fact, shall make these findings in the record. Now, in Brown, which was a Supreme Court case, it said that, absent a request, there doesn't have to be a formal finding. So I would agree that if the court, it either has to be in the entry or it has to be on the record. And in this case, it's in neither place. And there can't be a presumption that the court weighed all this. Otherwise, all you have to do is anytime that a motion to dismiss is denied or granted, then there need be no evaluation of Barker. The court doesn't need to say anything on the record based on what counsel is arguing here, that the record itself and what the court states is irrelevant. The only way that it speaks is through its record in this. Then Barker v. Wingo is meaningless. There never needs to be any sort of statement of any sort of evaluation. All that needs happen is motion denied, motion granted. And then, so we have to look at the record. And in this case, the record affirmatively shows there was no discussion about prejudice. There was no finding as to prejudice. There was no allegation other than the generalized one that I discussed with Judge Winkler. Other than a generalized boilerplate universal allegation, there was no showing of prejudice, and that is fatal to the trial court's determination. If there's nothing further.
Thank you.
Thank you.
Your Honors.
Your case has now been submitted, and we will issue a timely decision. Our last case for today is in Re JF. Ms. Kane, how much time would you like to reserve?
2 minutes, please, Your Honor.
Whenever you're ready.
Good morning, Your Honors. May it please the Court. In May of 2022, 16-year-old JF was pulled over by police. The sole basis for the stop was suspicion of overly tinted windows. Upon being stopped, JF immediately rolled down his driver's side window. However, without any additional justification, police then ordered JF to roll down all of the remaining windows of the vehicle.
I'm going to stop you right there. So I watched the video a couple of times, and it didn't seem like it was an order. The officer said, and I'm trying to find the exact language, the officer said something like, "Can you roll down all of the windows?" It was a question rather than an order, correct?
Yes, so you are correct. That is I believe, the exact language that the officer used. I'll note that the issue of consent was not challenged at the trial level or in briefing on appeal. I would also note that so I'll briefly address it, but if you want more briefing on that issue, I'd be happy to do that. But a traffic stop is, in every circumstance, a seizure. And when we are thinking about whether or not compliance with an officer's question amounted to voluntary consent versus just complying with an order of an officer, there are several factors that courts look at. A couple of the factors that I think are relevant here for that question are the age of the person, their knowledge. This is a young man. He's only 16 years old at the time. He had not had hardly any other contacts other than a minor misdemeanor prior to this. So he doesn't have a lot of familiarity with what he is allowed or not allowed to do. I think the other major question is, that's a factor that's relevant, is whether or not a reasonable person would feel free to not comply. And I think that this is an instance where a reasonable person, if an officer were to say that, would feel that they are required to do so. I certainly, as an individual, if asked by an officer to do that in the context of a traffic stop or seizure, I would feel like that is something I'm required to do.
What would be the relevance of that?
The relevance of,
Because the
it's,
testimony of the officer is that this was their sort of normal procedure, and that it was for the purposes of officer safety.
so the relevance with whether or not a person would feel free to say no.
Right, whether they're being, compelled to do something or that they're doing it consensually.
Yes, so one is because it's really relevant in this case because it is our contention that officers requiring JF to roll down all of the windows of the vehicle was an unconstitutional intrusion into a protected sphere where JF had a reasonable expectation of privacy. And this case was decided under Terry v. Ohio. And so as this court has recognized recently in In Re JT, under the Terry doctrine, a search and a seizure are separate actions that require their own independent justifications. And so in this case, before officers could order JF to roll down the windows so that they could see into the vehicle, it's our contention that they would need reasonable suspicion to support a belief that he was armed and dangerous. So before we can even get to the question about officer safety, I think we have to consider some of the other factors that are surrounding this case. Officers did not claim to have reasonable suspicion that JF was armed or dangerous. There's no evidence in the record that the stop occurred in a high crime area. There are no allegations of furtive movements. There's no indication that officers were responding to a report of suspicious activity. Officers approached the vehicle and communicated with JF in a relatively casual manner, suggesting that there was no genuine concern relating to officer safety in this particular case. And by all accounts, JF was polite, respectful, and compliant throughout the entire duration of the stop. And so to have that kind of intrusion without something more violates the Fourth Amendment.
Wouldn't the reason for the intrusion be weighed against the expectation of privacy or the intrusion itself? In other words, frisking someone is passing a different threshold of expectation of privacy and compared to rolling down windows. Do you understand what I'm saying?
Yes, I think I do.
Yeah. So, what has been developed as to requiring a frisk, should that be the same as to the rolling down of windows?
I believe that it should. And the reason for that is, although one has a lesser expectation of privacy in their vehicle than they would in their home, there is still...
Generally, people don't have their windows necessarily tinted, right? So when people are driving down the street or being stopped or whatever, seems that the expectation of privacy of being able, of not having seen what's in the vehicle is very different than being frisked. I don't think as I'm, living life, I expect to be frisked,
Sure.
But as I'm driving about, I think the expectation of, of what is seen and not seen in my vehicle is quite different.
So I think that's a really interesting point. And so as it relates to the front windows of a vehicle, I think you're absolutely right. The front windows are regulated under Ohio law, and they are only permitted to have a certain level of tint.
And I understand that from your argument, are you saying that the regulation is what determines it? That because it's not regulated, then the expectation of privacy is the same as being frisked?
So I think that where it becomes relevant is when we are looking at what constitutes a search, and as it relates to what our expectations are for what we seek to preserve as private. One of the factors we're looking at is whether or not that expectation is reasonable and whether or not it is something that society is ready to accept as a reasonable expectation of privacy. So just as when we're walking around in our day-to-day, we don't expect to be frisked. It is also true that as we're walking around day-to-day, if we're wearing a backpack, we don't expect to be told to be able to just open that up and show what's inside. And so as it relates to the window tint statutes, Ohio has expressly excluded rear windows from the window tint regulations unless someone doesn't have left and right rear view mirrors. And in that sense, the regulations help sort of illuminate what is kind of reasonable and expected under Ohio law. So there are many vehicles that are in complete compliance with Ohio law that have minimally transparent or non-transparent rear windows.
Okay. And again, opening up a backpack, I don't know if you're saying that's comparable to the windows, but I understand that you're focused on it being regulated. But it seems as if you're asking for the treatment of the rear of the vehicle, if it's tinted, to be pretty much the same as the trunk, the interior compartments. So there's case law that has developed as to when an officer can get into interior compartments and trunk and so on and so forth. And again, it's really that weighing of the expectation of privacy to the state's interest, right?
Yes.
And then there are some states' interests in some circumstances that then outweighs the expectation of privacy. So, we're trying to gauge of what is the expectation of privacy so that the officer's safety, and in this case, the officer testifying that this is their regular procedure, that just isn't good enough.
So I think it all exists on a little bit of a spectrum. So if we think about, for example, under Terry, and what people commonly think about as being a traditional Terry stop, so you're out on the street, officer has some sort of suspicion that you might be engaged in some kind of illegal activity, officer initiates that interaction, and they may only proceed with a Terry frisk if there is reasonable belief, justified belief that the person might be armed and dangerous. During a Terry frisk, the officer is not allowed to do a full search of the person. They're not allowed to
Which
check.
is what you're asking
Yeah.
us to apply. You said that
Right,
there
and
has
so
to
I-
be reasonable suspicion that this person is armed and dangerous before they can be asked or commanded to roll down their windows when their rear windows are tinted. I think I've articulated it pretty completely there.
Right, and so I guess what the line I was trying to kind of make is that I think that the order to roll down the windows is akin to that initial frisk. So it's not a full search. It's not the same. It wouldn't require probable cause or search incident to arrest that is necessary to do a full search of the vehicle. But I think that it needs to exist somewhere on a spectrum of, officers aren't entitled under every circumstance in any case to walk up during a traffic stop and say, hey, roll down all of your windows, just as they would not be permitted to, if you were driving, for example, a van that is used for transporting large items, an officer wouldn't be able to open up the back of the van, even though there could potentially be people in the back.
But it seems as if we were to decide that, that would be broader than the issue that's in front of us. Because the issue in front of us isn't whether the officer in any circumstance, at any whatever moment, can ask, assuming that the detention is lawful to begin with, obviously. It's whether in this case where the officer says this is our regular procedure and it's for officer safety, whether it is unconstitutional for the officer to, and I'm just going to assume that they command it rather than request it, just to kind of, command someone to roll down their windows when their rear windows are tinted.
I'm sorry, could you restate
So
the question?
if I understood you, you said, you seem to be directing the potential of us deciding something much broader than what's in front of us.
So I think that we can narrow it, certainly to the specifics of this case. So again, kind of coming back to the basics of Terry. So, we don't deny that there is reasonable basis to initiate the stop. One of the things that is particularly concerning about this case is it was not only that officers ordered JF to roll down the windows, but once he rolled down all of the windows, the officer asks, anyone else in the car with you? JF replies, no, no one else in the car. You can hear over body-worn camera the officer saying, no other occupants. You can actually see on the body-worn camera before he is up to the driver's side window, you can tell that the rear passenger seats are folded down. And so the reason that is alleged for ordering him to roll down the windows was just to make sure that there were no other occupants. But it is after that point that the officer then takes a flashlight and looks into the rear window and is checking to see if there's anything in the vehicle. And so I think that that is indicative of the fact that the officer was not merely asking him to roll down the window just so they could determine whether or not there were other occupants, but to be able to see into the rear passenger compartment. And that, I think, is an invasion into a private sphere, especially given that if officers were to approach, I think that they would be able to tell from the open driver's side window whether or not there were any other occupants. But even if that's going too far, I think if we kind of go back to the specific facts of this case, again, there was no other justification. It was just part of this stop for a misdemeanor offense, a minor misdemeanor offense that is suspected, not even verified at that point. And officers took a flashlight to then look into what had previously been a concealed private space and visually search that area.
Ms. Kane, your time is up.
All right. Thank you very much, Your Honors. And I would just ask this court to reverse and remand for proceedings consistent with this decision. Thank you.
Ms. Adams?
Good morning, Your Honors. May it please the court? I think we start with the analysis of this. The purposes of the entire stop was excessive window tint. And the officer's indication that we need to know how many occupants are in a vehicle, prior to approaching that vehicle in any traffic stop, but certainly when we talk about excessive window tint. And I think the body-worn cameras here certainly present this in the most polite, calm manner that the officers engaged in this stop.
And the
From
same could be
from the
said-
get-go.
The same could be said of the juvenile as well, wouldn't you say?
Yes, and I think that tone, obviously this could have been of the worst-case scenario as well. But I think even on the cruiser cam video, you have, if you look at that, I don't know that, I mean, I think the lighting, or the percentage they said was maybe 4%. These were extremely dark, very dark windows in the dark of night, and that's very visible on the dash cam video. But I think initially when the dispatch is responding, when they're engaging in the report to dispatch, immediately they're saying, we don't know how many occupants are in the vehicle. And when you, I guess, put both officers' body-worn cameras side by side, the request to roll down the windows is being made as the approach is happening. And I think that's another important factor here. When we look at this scenario, what we're supposed to consider is reasonableness of the officers. And this court must give due weight to the officer's experience and training and view that evidence as it would be understood by those in law enforcement. So I think under this scenario, nothing more reasonable than just simply, hey, buddy, can you roll down all the windows we need to see? And I think the magistrate's findings, if we look here, and I don't know that she actually timed it, but certainly I think that we can trust that that the timing here was less than 30 seconds, that Officer Harris was able to see that firearm and very calmly say, hey, in plain view, right here on the back, the back seats were folded down, but on that, near that headrest of the back seat, plain view, the firearm. I don't think there's anything unreasonable about the, shining a flashlight, or, this is, close to midnight that this occurred. And that's not to say that the officers were looking for a firearm, were looking for any particular item. Again, they're trying to see how many occupants, if any, are in that vehicle. So I don't think that there was any error whatsoever here in the juvenile court denying the motion to suppress. And unless there's any other specific questions, I will submit on my brief. Thank you.
Thank you. Ms. Kane, you have 2 minutes.
Thank you, Your Honor. So very briefly, I just want to address this, the question about reasonableness. And I think one basic point I just want to highlight is that I do believe that this ordering somebody to roll down the windows does constitute a search. This was done without a warrant. And so it is the state's burden to prove that there was an applicable warrant exception. In this instance, there was not. As to officer safety is absolutely a legitimate concern, and our cases bear that out. One case that I just want to highlight, though, that deals with officer safety that I think is relevant for our consideration is Pennsylvania v. Mims. And in that case, part of the Supreme Court's reasoning for allowing officers to ask an individual to step out of the vehicle during a traffic stop for officer safety, the court reasoned that that does not violate the Fourth Amendment because it is a de minimis extension of the seizure that's already occurring. And a person who's asked to step out of the vehicle is revealing little more than they would during the traffic stop if they remained in the vehicle. This is distinguishable from that because they did not ask JF to step out of the vehicle for officer safety during the stop. Instead, they required him to allow officers to look into a space that we have determined is subject to constitutional protection. If there are no other questions.
Thank you.
Thank you very much, Your Honors.
Your case has now been submitted, and we will issue a timely decision. And that concludes our cases for today. Have a wonderful day.
Thank you.